Take seats, please. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He or person having business with the appellate come here, give your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. Be seated means you're supposed to sit down. You didn't get that. We'll wait. So I guess most of you have been here before and you know the spiel. So please only request the time that you actually need to bring out the salient points of your arguments. We are fully familiar with your arguments and with your briefs, okay? People v. Juan Batista Abreu. 414. Justice Pitt Burke is recused on that matter. Lely v. Romanello.
For the appellant, 10 and 5, Your Honor.
For the respondent, 8.
6 and 2 and 6. People v. K. Lester Williams. 5-1. You didn't respond. You didn't request any time for argument, according to this.
Actually, I have requested, Your Honor. There was an error. I did call the clerk up that was told that.
Anyhow, 5-1 and 5. Thanks. Ferreira versus Wayne.
Claim for the appellant, 7-3, please.
6-2-6. People v. Christopher Flores.
Respondent request 5, Your Honor.
5-2-5. Poulos versus Pros on the move. Matter submitted. Hardyway versus Yap. That matter is submitted. Maldonado versus Hines, 1045.
Claim for the appellant, 5 and 2.
Defendant responded 3-1.
You have a cross?
Yes.
5231. 245 East 19th Realty versus 245 East 19th Street.
Defendant appellant, 5 and 5, please, Judge. Plaintiff responded 5 and 3. 5 for the HPS defendants, 5 please.
And Justice Friedman is recused on that matter. People versus Charles Osborne.
Did you say how many minutes?
That matter is submitted. The time requested on 245 is granted. Gavrilov versus Unger Consulting. That matter is submitted. Mercedes versus Coolwind.
Defendant appellant, 7 and 3.
Defendant responding to 5 minutes, Your Honor.
Defendant respondent calling in 5 minutes, Your Honor.
6-2, 5 and 5. Perkins Eastman versus White Plains Hospital. Dong versus, that is submitted. Dong versus GTV Media Group. That matter is submitted. First case for argument is People v. Juan Batista Abreu. As I stated, Justice Pitt Burke is recused.
Step up.
May it please the court, Laura McFeely for Mr. Batista Abreu. The sentence in this case was excessive and should be reduced for 3 reasons. First, this tragic incident was an aberration.
Are you requesting, I thought you were requesting the reduction in the post-release supervision.
No, he's going to be deported when he completes his sentence. We are requesting a reduction to the minimum of 5 years or somewhere close to that. Mr. Batista Abreu was a 55-year-old with no prior contact with the criminal justice system who was clearly experiencing a mental health crisis. His progress in controlling his behavior makes him unlikely to reoffend, and his age makes him particularly vulnerable in prison.
Because he's like 50 years old, right? So he's elderly?
He's 60, but we he has a degenerative disc disorder and osteoarthritis, but we also cited research in our brief saying that people, prison has harsh conditions and people.
I thought this was also the issue in terms of, you stated he had a cognitive disability, and that's why he was initially found unfit.
That's correct.
Oh, okay.
Yes, yeah, and we are arguing that his cognitive issues are a mitigating factor and make him less blameworthy than the typical offender.
You don't make light of the enormity of the crime, of course.
No, we do
I
not.
mean, he stabbed her 3 times and left her to bleed out.
We do not dispute the extent of her injuries.
And in terms of the bleeding out, he was aware of the fact that her condition was such that if she was left, and she was left there, and she would bleed out based upon her condition.
I'm not sure there's anything in the record to say that she was aware that he was aware that.
I thought he was aware of the fact that she was taking certain medication and had a certain condition, therefore, that would lead her to, again, bleed out if left without treatment.
That's correct. There is a line in the pre-sentence report about her saying that he was aware that she was on that medication. I don't think that there's anything in the record as to
He
his
stabbed her 3
knowledge.
times, right? And then he went to 2 different precincts to report it, but sort of minimize what had happened. Not that he was going to the precincts to get her help.
Well, he was going to the precincts to turn himself in, and I think
Well, he said something like, we just had a fight or something like that?
he said, I made a mistake. I did something wrong, so I went to the precinct. I think we need to look at his.
No, I'm saying when he went to the precinct, what he told the police officers was something to the extent that I just had a fight with my girlfriend, something of that nature, not that he had left her bleeding on the floor.
He did say that they had a fight, but then he also said that she was bleeding. And, I think we need to look at his statements given what we knew about his cognitive abilities at the time, which is that he was found not fit for trial. He didn't know the month or the date. He didn't know the name of his attorney. I think his statements indicate that he knew he'd done something very wrong, but he was still grappling to understand the enormity of.
What about his alleged statements to the complainant in terms of why he was stabbing her, why he stabbed her 3 times?
His statements to the complainant?
Right. Didn't he say something like, I forgot what it was, you deserve this, or now you're saying what you're going to get?
You were going to get it.
Thank you.
In the, I see, in the pre-sentence report?
No, in
Yeah.
her testimony. Her
testimony.
statements to the district attorney's office, and her statements was that he's made those statements to her.
I see. I think he was, his, again, we have to look at what he was saying with what we know about his cognitive abilities and the fact that he was found.
I'm sorry, he punched her in the face saying, I told you you were going to get it. When she begged for her life, she said, please don't kill me, as he stabbed her with a knife 3 times, twice to the torso and then to the upper leg.
Right, but again, I think, this is a case with very unusual facts, and I really do think that it was an aberration. He was 55 years old when it happened. He had never been arrested
And when he
before.
went to the precinct, he stated that he had a problem with his wife and might have nicked her on the hand with a pen. I don't believe there was anything in the record that he actually stated that he had stabbed her 3 times and she was bleeding on the floor. He stated, I might have nicked her on the hand with a pen.
His later statements to the police say with a pen knife, but I think what's important is that he immediately went to the precinct. He understood that he had done something wrong. I see that.
Well, then wouldn't he have called 911? But you have time on rebuttal.
Yeah, I see that my time is up, so I will sit down for now. Thank you.
Good afternoon, Your Honors, and may it please the court. Kalani Brown on behalf of the Bronx County District Attorney's Office. Your Honors, the defendant in this matter lured his ex-girlfriend to his apartment with the false pretense that he just wanted to talk, and when she had her guard down and her back turned, he punched her in the face and stabbed her 3 times, twice in the torso and once in the upper leg. The defendant did not call for help. He did not call 911. Instead, he left the apartment, he locked the door behind him, and let the victim bleed out. It wasn't until 3 hours later that he went to the 40th precinct and said that he had nicked his girlfriend on the hand with a pen.
Counsel, could you address the issue of the alleged cognitive defects?
Yes, Your Honor. Initially, the defendant was found not fit to proceed because of his inability to understand the nature of the proceedings. He was not able to have a factual or rational conversation about what was going on, the charges that were facing him, the incarceration time, things of that nature. And so once he was deemed unfit, he was admitted to the Kirby Psychiatric Center, where they had done additional tests with additional doctors, and they had deemed that it wasn't that he had a mood disorder or any type of cognitive disability. It was just that he was a native Spanish speaker, and so that language barrier made it difficult for him to understand the proceedings. He was a native of the Dominican Republic, and so he was not familiar with the United States criminal justice system. The defendant did not have much literacy, and so he wasn't able to read or write much English, and he had minimal education. And so for those reasons, they thought that based on those circumstances, that he was initially deemed unfit.
I'm sorry.
I guess the question that I have, or the concerns that I have to do with the fact that many people might find themselves in similar circumstances where they have limited education, limited exposure, because they're not born in the United States, but they don't get sent to Kirby. They don't get 71030'd. So why would this person be different, or why would he be different from a regular person who doesn't speak English?
Yes, Your Honor. So the first
Or
two
the
of-
same?
The first two evaluations, the defendant was diagnosed with an unspecified mood disorder, and so because of that diagnosis, he was legible to be admitted to Kirby. So it wasn't just that he had some type of
He was
language.
eligible, you mean,
He
because
was eligible,
the
excuse me,
730 was requested by his attorney.
by the judge.
Oh, the 730 was requested by the judge?
Yes, yeah.
And the disorder that he allegedly suffered from, that was the result of apparently a motor vehicle accident while he was still residing in the Dominican Republic in 2010?
That was speculated, Your Honor. It wasn't entirely sure what the issue was at the time, but based on those two evaluations, that's the only thing the doctors could maybe come up with to see why he couldn't understand the proceedings. And so what's important is that the doctors at Kirby were able to say that, okay, it wasn't an issue with the car accident, it was just at the time that him being able to not speak English, and his language barrier, his native, being from a native country, not from the US, that those additional things made it difficult for him to understand the legal nature of the proceedings. However, the defendant did say that he was not experiencing any mood disorders, he did not have any cognitive disabilities, any psychiatric disorders, and so the defendant admitted that he just wanted to do his time, that he was suffering from depression due to him being incarcerated, excuse me, but that's a normal feeling or common feeling for people, for individuals who are incarcerated. to
And
have
when you're
depressive
saying that he
moods.
expressed this is you're referring to at the time of the plea?
Yes, Your Honor.
Thank you.
So my question is, your adversary will raise the issue that if English wasn't his primary language and he struggled with it, how do you get past their argument that the appeal waiver is not valid?
Your Honor, the defendant had an official court Spanish interpreter present, and in addition to the assistance from his attorney, and the judge gave him ample opportunity to discuss the waiver with his attorney twice on the record.
And the appeal waiver wasn't Spanish, was it not? The written waiver?
Yes, the defendant was provided a Spanish and English written waiver in which he signed both.
Was he illiterate?
Was he
Illiterate,
illiterate?
yes.
Was he able to read?
No, I don't believe he was able to read the English version, but I believe he was able to read the Spanish. But with the assistance of the Spanish interpreter, the interpreter and his counsel were able to go through the waiver thoroughly, which he indicated on the record before he validly
you.
waived his right to appeal.
Thank you very much.
Thank you, Your Honor.
I just wanted to clarify one point, which is that he could not read or write English or Spanish, which made the oral colloquy particularly important. I just wanted to highlight a couple of additional mitigating factors for Mr. Batista Abreu. One is that he is unlikely to reoffend. None of the psychiatric reports noted any issues with his behavior. The Kirby report noted that he had good behavioral control, and he's been doing well ever since this incident. And the final point is that prison is a particularly difficult experience for someone of Mr. Batista Abreu's age, who's a first-time offender, and who has degenerative disc disease and osteoarthritis, as I mentioned earlier. So given that, we are asking for the minimum sentence of 5 years, but if not that, a reduction should be considered in light of his cognitive issues, his vulnerability, and the fact that he will be deported once he has served a sentence.
Thank you.
Thank you.
Lely versus Romanella.
Good afternoon. May it please the court. My name is Todd Kroner. I represent the plaintiff appellant Edward Liley.
Liley, thank you.
You're welcome, Your Honor. In his legal malpractice case against his Connecticut lawyers, arising from his underlying medical malpractice claims against the Hospital for Special Surgery here in New York City. I would like to address this afternoon 3 issues. First concerns the missing retainer agreement between the attorney and the client. Second concerns the missing termination letter concerning the lawyer's purported termination of the relationship with his client, which is inexorably intertwined with the agency issues in this case. And lastly, I hope to address the issue of spoliation. Concerning
That retainer agreement, though, provided, did it not, that if the medical analysis came back with a negative report, that the retention would be over? Is that correct?
That's half correct, Your Honor. The retention would be, in the words of just Judge Hagler below, self-executing and would end. However, where we do not have the actual retainer agreement, which the special referee found was actually at least partially executed, what we do have is a form of retainer agreement from Mr. Romanello, which says that the termination must be provided on reasonable notice in writing. And that's critical here, because the oral termination as a matter of law must be ineffective where the contract provides for written notice of termination. And further, Your Honor—
That's provided both sides signed it.
That's an issue within an issue. But just to finish on the requirement of written termination, those words are not gratuitous. Those words are also consistent with and mandated by the Code of Professional Conduct,
Assuming that the retainer was fully executed.
which requires written notice of termination of a contingent fee agreement.
But
So,
assuming that it's fully executed.
assuming that it's fully executed, but
Is that the requirement in Connecticut, too?
I don't understand in either New York or Connecticut that the Code of Professional Responsibility is so exacting as to saying in an agreement that is countersigned by the lawyer where we have an agreement. And we have the agreement with—
That doesn't
Does
make
this
sense.
writing requirement to terminate the law in Connecticut?
we have an agreement, if I may. We have an agreement between the attorney and the client, even if the client alone signed, when the attorney completes the agreement, with or without a signature, by undertaking to perform and manifesting his intent to be bound.
That doesn't make any sense, counsel. The
Okay.
question becomes, the threshold question is, was there a fully executed retainer agreement?
So the answer to that question is, we don't know. And the reason we don't know is because the lawyer lost the agreement, which the special referee specifically found. The lawyer handed to the client, that the client signed, that the client handed back to the lawyer, and vaporized after that. Now,
But wasn't in this record a discussion where the defendant said, I need to think this through? I mean, there was a meeting between him and the disbarred attorney and your client.
correct,
To discuss the case.
correct.
And they discussed it, and it was clear on this record, based on affidavits, et cetera, that suggest that I got to wait and see here. So, so the formal closing by signing was not made clear.
So, two things. First, spoliation. The referee and the lower court
I
erred.
think you're jumping ahead, though, because the issue of a negative medical report was dispositive as far as the issue of representation was concerned. And here, the plaintiff was alleging that his ankle surgery resulted in a perforated or ruptured bowel.
Correct.
Am I correct?
Yes,
So,
sepsis.
under that set of circumstances, wouldn't the disclaimer, if we find a negative medical report, we're not going to represent you, doesn't that take on a significance?
There are three issues that I see swirling among the several questions from the bench. Going in reverse order, there's always the opportunity with one negative medical report to find another. And what doesn't make sense in that logic is then why was a complaint filed on behalf of the client without the client's notice? In terms of the temporizing.
Well, that brings us to a different issue, but continue.
In terms of the temporizing, there was no temporizing, there was active investigation. It is correct. There was no promise to start a lawsuit, but there was an undertaking to investigate the claim. And the lawyer
And
executed.
that means the lawyer is retained.
That means the lawyer is retained on an investigative basis to look into the case and therefore has a duty when he terminates the investigation.
Even if he
to
never
let the
signed, even if he never signed the report.
When the contract is made when he undertakes to perform.
It sounds like the contract is made by what you're telling us, that when he gives him a copy of his retainer agreement, he's retained.
And then goes,
Even though he never signs it.
and then goes off and investigates the case. That's correct, Your Honor. But there's one other elephant in the room.
And we'll hear from that elephant on your rebuttal. Thank you.
Thank you, Your Honor.
May it please the court, my name is Jeffrey Pesky, and I'm with Vute, Lorfink, McAndrew, Meisner, and Roberts, and we represent the Romanello Law Firm and Joseph Romanello, the respondents in this matter.
So how important is a fully executed retainer in this context?
Well, I think it's critical in this context because the retainer agreement sets forth the contract by which they are to operate. And if both parties do not sign that, it is not a contract. Moreover, it is our position, and it has always been our position, and it was the testimony by both Romanello and the co-defendant Dimian, who is not a part of this appeal, that there was no retainer agreement ever executed. So it was never even presented because it was just them trying to investigate. What was handed to Mr. Liley was an authorization to obtain the Danbury records, which we produced in discovery, his signature on it. There was no retainer agreement ever produced.
That even brings up another issue in terms of even if there was a retainer agreement or an agreement, would it not have just been for work to be done in Connecticut and not in New York?
Correct. So my client is not admitted in New York, has no contacts with New York. So if it turned out that this case, Mr. Crowner believes that the case can only be brought in New York, I say it could have been brought in Connecticut as well. They have offices in Connecticut, the defendant hospital special surgery. It could have been brought, but they didn't have that thought process yet. The thought process was let's investigate, and it was only an investigation. When they came back with that negative medical review saying that there was no medical malpractice, the referee found they brought the client in to discuss it, told them, yes, it would have been better if it was in writing. It was not. But he brought the client in and said, we have a negative review. You need to find another lawyer.
I would imagine that in the medical malpractice context, clients frequently come to plaintiffs, med mal attorneys, and present their case, and the lawyer says, well, let me check it out. And because the lawyer says, let me check it out, it doesn't mean that he's been retained.
Correct. I say it does not mean he has been retained until there's a formal retainer agreement. Just because an attorney has decided to investigate does not mean there's a formal retainer.
Was
However,
there anything in the record that would indicate that a retainer agreement was created, but it was somehow destroyed, lost, concealed?
there was nothing in the record of that. Mr.
Well, plaintiff did state that he signed a retainer agreement, right?
The plaintiff said he signed a retainer agreement. Joanne Budd recalls that a retainer agreement was executed. There's two people.
Is that the
testifying.
girlfriend?
That was, yes, that was the girlfriend at the time. And there are two witnesses that say no retainer agreement was ever executed. And so that goes to Mr. Kroner's spoliation argument, which was never made except for in a footnote. We have not had the opportunity to oppose that spoliation argument with affidavits, with what investigation was done to locate any documents, and to reaffirm that there was no retainer agreement.
Can we address the issue of personal jurisdiction to the extent that Mr. Romanello hired a disbarred attorney to work in his office, and then that person went out and filed a complaint in the Southern District, having drafted that complaint? Don't we have a can of worms there?
I don't defend my client retaining a disbarred attorney to assist with legal matters on occasion, and that is an issue for the Connecticut courts to handle if they so choose to. But what I do say is that the leading cases on the issue from Court of Appeals, Cruder and Ford, both specifically state that the New York Act has to be with knowledge and consent of and benefit the principal. And here, Romanello had no knowledge of it, and that's what the referee found.
Dimyon specifically stated that Romanello did not know what Dimyon was doing.
Correct. Dimyon testified that that Romanello had no knowledge of it, and when Mr. Kroner sent his letter indicating a lawsuit were to be filed, there was quite a heated conversation between Romanello and Dimyon, which they both testified to. Additionally, Dimyon also testified that several months before the filing of that Southern District New York action, he had conversations with Liley, who they're close friends. Dimyon and Liley were very good friends. He would bring him to rehab and other places. They'd have dinner at each other's houses. They had a close relationship. And he said that it was months before the Southern District New York action was filed that Liley told Dimyon that he had hired an attorney he had met in rehab. So he had thought everything was taken care of. And in a subsequent conversation, he had found out that he, in fact, did not hire any attorney to represent him in the case. And so Dimyon took it upon himself to rush and prepare a Southern District New York complaint and then file it after getting the filing fee from the plaintiff, Liley.
But the bottom line is that the testimony was that Romanello had no idea what Dimyon had done.
Correct. And
it was not done on his behalf or with him.
Correct. And there's no contrary testimony to that as well.
And the plaintiff never put forward any information on this record that suggests that Dimyon was acting as an agent on behalf of the defendant law.
Correct. And he had, the plaintiff, Liley, had gotten several mailings from the Southern District New York Court indicating that the case was pro se. And he testified he never got any of those mailings, but their star witness, Joanne Budd, said, of course we got the mailings, and I discussed it with him, and he became very furious. I'm sorry, Liley. I apologize. Furious. I'm sorry, Liley. I apologize. And so, you know, it's an inconsistency between their two witnesses of that Southern District New York action. But I think it is very clear that he received those notices and he knew he was moving forward with the case pro se and not being represented by Romanello. Thank you very much.
The elephant, Your Honor, is how much material can the attorney destroy and not be held accountable for? The issue is one of spoliation. We're talking about, at the outset, an engagement letter. And there was a framed issue hearing. And it was a specific finding of the special referee that that engagement letter existed, which Romanello denied. He perjured himself. He denied that it existed. He didn't say he didn't recall. He didn't say he didn't remember. He absolutely denied there was no such letter. But the special referee found that there was, and we know that it was at least signed by the client. That's where we start. Now, we don't have that letter today. And so the question under the spoliation doctrine is, Do we assume it was never signed by the lawyer in favor of the lawyer and draw that inference? Or do we find in favor of the client where the jurisdictional facts have been lost or destroyed by the attorney who was duty-bound to maintain them?
Did you represent your client below? Did you represent your client below?
Yes.
So why didn't you make a motion, a spoliation, a formal spoliation motion?
We did not make them.
To, give me a second, to strike the answer and all the other sanctions that would be potentially available for you?
That's a fair question, Your Honor, and we didn't make that motion. We were just doing jurisdictional discovery, but for sure, we preserved the issue below and raised it 3 times in papers and once in argument, simply asking for the evidentiary ruling of adverse finding. The most important case I would suggest here is that of Judge Jack Weinstein in City of New York versus A1 Jewelry, where he explains in a jurisdictional case involving spoliation, since the necessary jurisdictional information is in the exclusive control of defendants, where they have failed to provide the information, this court finds that plaintiffs have satisfied their burden and the case should proceed.
So counsel, I just, one last question. Your client testified that he signed this retainer agreement, is that correct?
True.
Did he also testify that Romanelli signed the retainer agreement as well?
He offered no testimony concerning that fact.
Thank you. Thank you both.
Thank you, Your Honor.
People v. K. Lester Williams.
Good afternoon. May it please the court, Shayna Watrous on behalf of Key Lester Williams.
Counsel, I just want to start with the Kroll case, which was decided by this court about 8 months after the judge below made this particular ruling. So he didn't have the benefit of this decision. And leave was denied to the Court of Appeals. So this Kroll decision is, in fact, applicable to these facts. Why should we distinguish it, or why should we change it? Because I know you make that argument in your brief that we should, and you have 3 of the judges on.
I was just going to say, given the fact that you have 3 judges who sat on the Kroll case on this particular bench.
We're not arguing that you should distinguish it. That case applies directly to this case. In Kroll, the court was concerned with 2 issues that were equally problematic related to the Fifth Amendment. One was that someone could face the penalty of their self-incrimination being used against them at trial. The other one was the potential perjury charge. But either of those would have been enough of an issue to implicate the Fifth Amendment. And where Mr. Williams had a pending appeal and had gone to trial and was worried about the potential for his statements to be used against him at a new trial, Kroll's holding applies here. I would note that, the Hobson's choice, which the court in Kroll sought to prevent, is precisely the one that Mr. Williams faced at his SORA hearing, and we're asking that this court reverse the 10 points assessed under Factor 12.
Well, the people, of course, is that Kroll be distinguished on the grounds that the defendant affirmatively asserted his innocence. I think in Kroll, it wouldn't have been possible for the defendant not to respond to the questions or the situation that developed in terms of his participation in sex offender treatment. But here, it's what he says upon admission to corrections, right, and when he fails probation. Wasn't the defendant in a position in which he could have just said nothing without any penalty? Which would not be so in Kroll.
Well, that's exactly what happened in Kroll. In Kroll was telling everyone that he was innocent, affirmatively stating his innocence. It wasn't simply remaining silent.
But he's in the program, and being in the program, he's got to come forward and admit his complicity in the crime. So that sets up you're forcing him to say something that he may not want to say, and if he doesn't say it, he's going to be penalized for it. But here, couldn't defendant just have kept quiet?
He could have kept quiet the same way that Krull could have kept quiet and didn't, and this court in
But
Krull.
Krull, wouldn't he still have been penalized for not have shown that he accepted responsibility? I mean, that's happening in the context of a treatment program while he's incarcerated, right? Here he comes in front of probation and he's asserting his innocence. He didn't have to say anything.
Well, Krull was not just denying his responsibility to his sex offender treatment program. He was, writing to the court, writing to the board, saying I'm innocent, doing a lot more than just not saying anything. And this court in Krull said, we can't. I think the words were. Can't find it exactly, but it was something along the lines of, we can't define exactly how someone asserts their Fifth Amendment right.
Well, let me just bring this point, because I think another distinguishing factor, maybe, if the people were going to argue this, is that Mr. Williams didn't testify at trial and Mr. Krull did. Is that something that matters?
No, that matters to the perjury point, but it doesn't matter to the anticipation of a new trial and your statements potentially being used against you. So again, the fact that there is this other significant Fifth Amendment issue that is implicated here, it doesn't actually matter that he didn't testify at trial. So there's no further questions. I'll reserve for rebuttal. Thank you.
Thank you.
May it please the court, Charles Wan for the respondent. Defendant here was not faced with.
Even if the distinction you would have us make, even if we were to make the distinction, even if the factual distinction which you are asserting is true, and let's assume that it's true, doesn't the defendant still get the benefit of the Fifth Amendment here? Because in the context of his denying his involvement, he says, I'm appealing. Isn't that sort of another way of asserting his privilege?
If the defendant simply said, I'm appealing, it's not quite the same as him not accepting responsibility. Because he could have been said, I'm appealing for my sentence or for other reasons. So it would not necessarily have been used at the SORA hearing to say he did not accept responsibility. Here, the defendant absolutely had the right to just say, I don't want to make a statement, or as noted, he could just simply say, I'm appealing, and leave it at that. And his statement would not have been used against him at the SORA hearing.
But in the Krull case, the defendant there also maintained his innocence. He testified at trial. He said the same thing to probation, as the record reflects, and as counsel indicated, he was writing letters to the court. What's really the difference here?
Well, in Krull, the court found the key part to be the fact that he had to admit his guilt or be removed from the treatment program. Here, defendant was not faced with such a choice. He denied his guilt when he was first admitted to the correctional facility, but it did not prevent him from being admitted into the treatment program 2 years later. So he was not facing any kind of penalty.
What you're saying is that he's being penalized for asserting his innocence, whereas here he didn't have to say anything.
Correct, Your Honor. He was not necessarily asserting his Fifth Amendment privilege. I don't believe, even in Krull, the defendant submitting letters would necessarily be him asserting his Fifth Amendment privilege, because, again, in those letters, he did not have to submit those letters. He voluntarily submitted letters, just as here, defendant Williams did not have to state that he is innocent. He could have simply said, I'm appealing my conviction, or he could have just declined to make any kind of statement.
So counsel, here, the defendant denied guilt before both probation and corrections, right?
Yes, Your Honor, but the correction statement was at the initial stage when he was first admitted. It was not in relation to his being enrolled in the treatment program, which occurred 2 years later.
So my question is, are you asking us to narrow Krull, to narrow its application, to modify it, or to overrule ourselves?
No, Your Honor, I believe the Krull is based, even in the decision, I believe this court said it is based upon the unique facts in Krull. I think Krull, I'm not asking to be overruled necessarily, but I think
I think you said that in your papers.
Well,
Continue.
we do dispute whether the applies, but I think short of overruling, I think it should still be, if the court does not want to overrule it, then it should still be limited to the facts of the case where defendant is faced with what this court called the Hobson's choice, where he has to admit guilt or be removed from the treatment program, which was not the facts here. So we're just asking that based upon the fact, which is distinguishable from Kroll, that the SORA court appropriately applied the 10 points on their effect to 12. If there are no further questions, people request an affirmance.
Thank you.
To be clear, the Hobson's choice that this court was concerned with in
How would a defendant ever have points asserted against him under Fact 12 if he has an appeal pending?
if that person,
Could you give me an example of a case where there could be an adjudication of points against him under Factor 12 when there's an appeal pending?
so if that person didn't go to trial, then Kroll wouldn't apply to that person. This is the very narrow case in which someone went to trial and then got a short enough sentence that the SORA hearing happens during.
And in fact, in Kroll, that was one of the distinctions that was made with the plea of guilty and then the maintaining of the innocence, the conflict there, right?
Yeah, so it only applies to people who are anticipating that new trial from the trial that they had. And I would just also note that
You're saying jury trial plus pending appeal.
exactly,
equals parole.
exactly. I would note that the Hobson's choice was not about the being penalized for being removed from the program. It was about being assessed these points and being given that higher risk level adjudication, which is what this court was concerned with.
Thank you.
Thank you very much.
Faria versus Wayne.
May it please the court, your honors. Matthew Gammons for plaintiff appellant. There is absolutely no weight of evidence. There is no valid line of reasoning in this case that a jury could have found the decision or come to the conclusion that they did. All the parties and the experts agree that this cut, this damage to the pulley does not happen during this operation unless it's malpractice. Everyone agrees with that. The experts, the defendants, no one disagrees.
Wouldn't the
Yes, Judge.
problem with the pulley have shown up right after the surgery if it had been cut at the surgery?
No, Your Honor, absolutely not. The bowstring that happens would happen if you have a complete rupture. The testimony from the plaintiff's expert was that it partially ruptured, that they cut it, that they nicked it enough to cause it to be liable to rupture later. What causes it to rupture later, months later, is the continued physical therapy, the aggressive physical therapy that's ordered by the doctor. So over time, it does rupture, like a rubber band being slightly cut with scissors. Over time, using it will cause it to rupture.
So how does the trip, the overseas trip that occurred between February 7th and March 10th of 2014 factor into this?
It doesn't.
Plaintiff agreed that something happened to her finger during that period when she was overseas, but she denied sustaining any kind of trauma or injuries, right?
Exactly.
And at the same time, she's somebody who used to do roller derby.
Right,
So,
roller derby.
given this particular configuration, isn't a jury reasonably able to come to a decision? They look at the experts on one hand, they look at the experts on the other hand, they listen to the testimony, they look at all the documentary evidence. You want us to set aside a verdict?
Yes, Judge. The line of reasoning that defendants presented was fantastical and based on speculation, which they themselves admitted. As far as the ecchymosis, the bruising that was noted to the finger on the vacation, she specifically said, I noted it without any injury, without anything happening to it. I didn't do anything to it, which is also consistent with the fact that that's when the rupture occurs. Over time, the rupture is going to happen. When it happens, it causes bruising. Completely consistent, meaning you see bruising, but you have no trauma that caused it. And there was...
She has sarcoidosis.
Correct, and that was actually the biggest point, Your Honor, that should have never been brought into this trial. That was literally not in the 3101D. It was brought up after I had already put on one of my witnesses. It's brought up in the middle of trial for the first
At
time.
what point was the condition disclosed? Is it fair to call it an
Deposition, Judge.
autoimmune
Autoimmune disorder. Yep.
disorder?
It was disclosed during a deposition. Defendants demanded some discovery. We argued about what that was. We gave them limited discovery because we didn't think a lot of it was relevant. They didn't go to the court and argue. So we had what we had going into trial, which was they knew sarcoidosis existed, and they did not put that in their expert disclosure. And then they specifically laid a trap and opened the door for that at trial. They spent a lot of time making sure that at the end of defendant's testimony, unsolicited, he said, by the way, there's been new facts I found out that I should mention. I didn't take the bait. I didn't say anything. I sat down. First question from the defendants in cross-examination with their witness on the stand. Sir, what were those other things that you just found out? Oh, sarcoidosis. Okay, and that's how it's introduced to the trial. The only question in this case is what caused the rupture to happen? What actually caused it? We presented good evidence as to what caused it. Defendant's argument as to what caused it was sarcoidosis. And he specifically says, the defendant's expert, that he doesn't know, and that's speculation. It's just a mere possibility, but he was allowed to float that noxious possibility before the jury, which the jury can latch on to now. And that's what I'm talking about when I say the fanciful line of reasoning. That is not based on anything but speculation, which he himself admitted in the testimony, said very specifically, I don't know. It's a possibility.
So, counsel, the jury made a determination. They reviewed the evidence. They listened to the testimony of the competing experts, and they made a determination.
It's not your standard competing experts because you don't have anything that's offered by them that's non-speculative. They cannot base it on a speculative argument.
Dr. Botwinick?
That was the defendant's doctor, yes.
Right.
Yeah.
The test stated that that he cut the A1 pulley and stopped before the A2 pulley. Denied cutting or damaging the A2 pulley.
And then he showed the diagram.
But he knew he didn't because he could see the A2 pulley during the procedure.
And Dr. Botwinick's testimony is completely non-credible since he put the incision line in his own diagram over the A1 pulley. That is no one questions that. He put the diagram into evidence. He said, I did this. It's over the A1 pulley. His own expert said, that's not where the incision is. It's over the A2 pulley.
Doesn't your version of this require the jury to have found that Dr. Botwinick was so incompetent that he mistook the A2 pulley for the A1 pulley?
No, as they've talked about in surgical terms, Your Honor, the hand surgery between the A1 and the A2 pulley, you can just look at your hand. The amount of space we're talking about is tiny in surgical terms. So being there, and by the way, he did say, remember Dr. Botwinick said, I entered the bottom of that.
He knew the difference between the two.
You can get turned around while you're doing a surgery, and that was certainly what was suggested, but the credibility of Dr. Botwinick is destroyed.
But he also said that if he had in fact cut the A2 pulley, there would have been obvious prominence over the phalanx.
That's only if you have bowstringing, Judge. That's the point. And that's what they've been trying to convince, Your Honors, is that the bowstringing shows that she didn't have it, but that was never the argument. The argument was that it was partially cut, which would not cause bowstringing. That was testified to by our expert and also by the non-party treating physician, Dr. Cadiala, who said, no, it would only happen after full rupture. We are not claiming full rupture occurred. We're saying it happened when you saw the ecchymosis, which is in March.
Thank you.
Thank you, Your Honors.
May it please the court, my name is Nicholas Herzler. I represent the defendants in this case. Your Honors.
When did you first become aware of the sarcoidosis?
Your Honor, during it was mentioned during the plaintiff's deposition, but it was not mentioned that she had been treating for the past 4 years.
That only came out at trial, isn't that correct?
Yes. And the plaintiff conceded during the trial that records should have been turned over on that, and we got 1,200 pages of records during the trial. So if anything, it was the defendants that were prejudiced by that late disclosure. The lower court has a lot of discretion with those types of motions in limine and discovery rulings. The court properly held that the plaintiff should have disclosed those records. The plaintiff also had an opportunity for rebuttal testimony, and it was relevant to the plaintiff's damages. So there was no error, but even if there was, it was harmless in this case.
Well, the court denied the plaintiff's motion to preclude the evidence as a sarcoidosis, right? Wasn't there a motion by plaintiff to motion at limine?
Motion in limine by plaintiff. That was correctly denied by the lower court to preclude the defendant's experts from talking about sarcoidosis.
Is tensionovitis a forerunner of sarcoidosis?
Your Honor, that's not a question. I mean, there was testimony by Dr. Green that could impact the plaintiff's diagnosis in this case, but it's not our burden of proof to show a cause of the rupture. There was only one question on the verdict sheet. Did Dr. Botwinick cut the pulley during the surgery? The parties agreed on the language of that.
And
of
so
the
he
verdict sheet.
testified that he didn't, because if he did, there are various reasons why he would have noticed it, et cetera. But he also apparently confused the two, the A1 and the A2 pulleys, right?
Well, Your Honor, that only comes from Dr. Miller, and she wasn't there. She didn't do the operation. Dr. Botwinick did. He's the only person who, and also, let's not forget physician assistant Wayne. She was there. She said the same thing. They prepared a contemporaneous operative report. Even Dr. Miller admitted that a contemporaneous report is more probative. So how can Dr. Miller come in and say, oh, well, he cut the pulley, even though I wasn't there, and there was no symptoms of it until 4 months later. But I'm going to say that he cut it because that helps my case.
And that doctor, the expert, plaintiff's expert, actually testified that that would be something that would be in the operative report, and it's not there. There was no deviation.
Exactly, and even Dr. Miller admitted that that if the report is accurate, then he didn't cut the pulley, and the report says what it says. He would have had to have said in the report there was a mistake, there was a cut of the pulley, and then we had to take measures to address it. So I only need.
So where are they getting this nick? Where is that coming from? It sounds to me like it's speculation.
It's complete speculation, Your Honor. I mean, the evidence in this case is, I only need a little evidence to uphold this verdict. I have a ton of evidence. I have physician assistant Wayne, I have Dr. Botwinick, I have the operative report, I have 4 months of treatment after the surgery with no evidence of or diagnosis of any rupture until March 20th.
So opposing counsel doesn't think it's of significance, but what is the significance of the fact that a considerable period of time goes by post-surgery in which there are none of these symptoms?
The significance of that is there was no rupture, there was no cut of the pulley, and there was no rupture until there was trauma. And by the way, what was not mentioned up until now is the April 2014 MRI, which showed trauma to the same area. And Dr. Miller testified that, oh, that doesn't matter because there's a mistake in the report, but she was not credible on that point. Again, conflicting expert testimony. The jury is entitled to resolve that. Plaintiff relies very heavily on diagrams, but as multiple witnesses testified, the diagrams are just initial sketches to give the plaintiff an idea of what's going to happen.
Dr. Miller's assessment ultimately relies upon Dr. Botwinick's initial sketch, right?
Right.
Based upon that the conclusion is reached that the A2 is cut.
Right, but the pulley is not, I mean, the diagram is, it's, first of all, it's just
No, the operative report doesn't show that.
the operative report.
Doesn't show that the A2 is cut.
Right, so how does that, you know, how does the diagram trump the operative report? The jury is entitled to resolve these issues in favor of the defendant. They did. It's the only question on the verdict sheet. I think the panel understands my argument, unless there are any questions.
Is there any indication that the jury was confused as to what the experts testified to?
There's no evidence of any questions, you know, requests that the court read back testimony for clarification. There's no, you know, evidence of the jury, you know, asking the court for a continuance or anything like that. So no. So I mean, I think it's just straightforward, relatively straightforward case of a lot of evidence in support of a verdict that can't be overturned just because the plaintiff disagrees with the result. Unless the court has any questions, I'll rest on my brief.
The motion in limine that was denied, that was denied for me, was to allow them to present sarcoidosis as an issue of damages. Very specifically, that's in the ruling from Judge Angoran. Instead, defendants opened the door and testified to causation. So to the extent that the judge denied my motion in limine and allowed the testimony, he said, it can go to damages. You can talk about it as to damages later. He did not say it could go to causation. So again, they went in and they did something not only beyond the 3101D, but beyond the motion in limine and the judge's order. And the judge, in response, thought he was fixing it, by punishing them and allowing me a rebuttal witness. The problem is that a rebuttal witness at that point, this specious theory, this fanciful theory is already out there now, and the jury is allowed to
I
then.
mean, you did bring up the sarcoidosis subject in your direct examination of Dr. Miller, did you not?
That was after they had brought it up, and I had to respond to it, and I responded to only the comments made by Dr. Botwinick, nothing further. I limited it exactly to that, but there was in no way I could not respond to Dr. Botwinick, who had just testified to causation as this being an issue. You couldn't possibly.
But at the end, Dr. Miller's opinion is primarily based upon that initial diagram in Dr. Botwinick's medical record.
Not at all, Judge. She testified, and I have the pages. I know defendants said that in their brief, but she testified very clearly to reviewing his entire chart, to all of the records, to all of the deposition testimonies. There was absolutely nothing in there that said that she didn't read the operative report, although that was said by defendants in their papers. But if you read the actual quote from the page they cited, she does not say that at all. And as far as the defendant expert contradicts the defendant on the location, says no, it is over the A2 pulley where you went the incision. His diagram, the defendant's, is underneath where your MP crease is here. MP crease on the diagrams they show, you can see where that is. He makes a dot right on the MP crease.
Yeah, but Dr. Green said that could not form the basis for an opinion as to whether there was a departure, because he stated that it was only a drawing of where a bump was palpated.
No, Judge, that was based on what he's talking about is the diagram in his office chart, not the diagram that we did at trial that the doctor said was accurate and precise.
Well, but Green also said that if Botwinick had in fact cut the A2, if it had been severed, it would have the statement that it would eventually stretch and rupture was inconsistent with the function of the A2 pulley, right?
Not at all, Judge. That's
what he said, but that's what he testified
He
to.
testified that once that if it was partially ruptured, it could be liable to rupture further. He absolutely agreed with that. And the testimony and the symptoms that the patient had, the plaintiff had after the surgery, were consistent with it. She just didn't have the bowstring. That's the only symptom that's not
He said
consistent.
it would not be consistent with producing bowstring.
Right. So we would not expect bowstring, but we would expect symptomology, and she did have it. She complained of consistent swelling, pain, and it would go up and down. That is not consistent with something that is healthy and good. That is consistent with something, there's a problem there, and it should have been diagnosed. Therapy should have been stopped. Yes,
She
sir.
had full flexion.
Sorry?
She had full flexion.
She did not have full flexion. At different
December?
times. Right afterwards, she complained of swelling and restriction, Judge. Right after she did. Read the actual medical, the brief by defendant suggests
I
that.
thought in her testimony she said in December she had full flexion. Yeah.
Right, and then in January, it was a little off. The point is it was up and down. She was having problems with it throughout. It was not consistent every single time she went, but you had swelling, you had pain, you had restriction. So we're not talking about a perfectly healthy hand, and that is consistent with a partially cut A2 pulley. But the biggest point, again, is how can he accept the credibility of the defendant when the defendant and the defendant's expert absolutely say you're wrong? They point at each other and say you're wrong. It was over the A2 pulley. Defendant says it's over the A1 pulley. They have zero credibility. How can that have any weight of evidence if they have contradicted each other on the primary point of where the incision was and where the injury was?
Thank you. Thank you both.
Thank you, Your Honors.
People v. Christopher Flores.
Good afternoon, Your Honors. Victorian Wu, Office of the Appellate Defender for Christopher Flores. The evidence in this case did not establish beyond a reasonable doubt that Mr. Flores displayed what appeared to be a firearm, an element necessary to elevate the charge of third-degree robbery to second-degree robbery. The prosecution's case hinged on the notion that Mr. Flores' hand was in the golden gift bag during the brief incident.
Well, it was a little bit more than that, right? Did the defendant not produce a note to the teller stating, I have a gun? Well, give me the money, whatever. Demanding money and also stating, I have a gun. And then he's holding a bag and he has his hand in the bag.
So two things. The Court of Appeals has said that words alone cannot satisfy the display element, so we really have to look at the conduct that the prosecutor alleged.
Right, so we have words, I have a gun, and then we have his hand in a bag, which the people argued could readily conceal a weapon.
Right, so the reason why the brief positioning of the hand, even if you find that it was in a bag, that does not support a reasonable belief that a firearm was being manifested, given the way...
Whose reasonable belief are we talking about? Is it that what the victim reasonably perceives, or
Yes, the
something else?
complainant has to reasonably believe that the gesture or the conduct
Why isn't it
manifests.
fair then to say that someone hands you a note, I have a gun, they have their hand inside a bag, which can conceal a gun? Why isn't that fair for the jury to reasonably believe that this person perceived they had a gun?
That is because of the way Mr. Flores handled the bag in the moments beforehand. So the video shows that he has a bag, he lowers on the counter in front of the teller, then he opens it toward the teller, and someone who has a gun and intends to rob a bank with a gun would not do that
That's
to the teller.
speculation, counsel.
Oh no, the video shows that he opened it toward the teller.
We saw the video.
We all-
I don't think so.
Oh, well, I mean, we have to
I don't think you
disagree
really
on that then.
responded to Judge Pittsburgh's question. Whose reasonable belief is it? I mean, the teller gets a note from someone who says, I've got a gun. It's not an unreasonable belief for that teller to believe that the person has a gun.
Well,
So-
it might have been reasonable based on the notes, but again, the display element requires some kind of conduct. And actually, I would note that the
Is there a
complainant...
need for some sort of objective reasonableness to what we're dealing with here, or?
Yes, in accordance with the Court of Appeals.
Is that your position?
Yes.
But besides the bag, the video shows the defendant, whether you want to say putting his hand in his pocket or patting his pocket, you definitely see him going to his pocket as he's approached the teller. Why doesn't that also support the idea that he's got a gun?
That is because the Court of Appeals has held that the witness must witness the conduct that is at issue. And here the
This is
prosecutor
happening
conceded...
right in front of her.
Right, but the prosecutor conceded that the teller didn't testify to seeing any patting gesture
She may
while
not
she
have
was on the stand.
testified, but we see the video, and the jury saw the video, and whether the teller testified to it or not, we see a defendant going to his pocket as he's told the teller, I've got a gun.
Right, I think our position is that because there was no testimony from the teller saying that she saw that gesture, that could not
Consider
support.
what the video shows.
Again, because there's no evidence that she testified to that
She
fact.
didn't
and
testify,
saw that.
but she didn't say, oh, I didn't see him going to his pocket, did she?
She did not say that either, Your Honors, that's correct.
But she did say that he passed a note saying, I have a gun, and that his hand was in the bag during the much of the encounter with her, right?
Right, so for the reasons I've stated, I believe that video
So
does...
why would a reasonable bank teller who is presented with a note not believe that the individual did in fact have a gun, given all of the circumstances?
Again, I think she may have reasonably feared the gun based on the note, but the display element requires some kind of conduct. And on cross-examination, she did concede to defense counsel that the bag was open toward her. That is on pages
But then but
110.
that's not conduct, right? That's based upon your line of your argument, she would have to actually see the gun, but I don't think that that's what the case law requires.
No, she doesn't actually have to see the gun.
But you're saying that because it was open towards her, I mean, his hand was in the bag.
Right.
We've all seen the video. His hand was in the bag.
And there was also no testimony that you could actually see inside the bag.
Right, she said on the stand that she could not see fully inside.
Exactly. And the video doesn't, when you watch the video, you can't see inside the bag either.
That's correct, yes. And if I could briefly address the excessive sentence point.
Certainly on rebuttal.
Thank you.
Good afternoon, Your Honors, and may it please the Court, Andrew Chung for the people. I'd like to begin by talking about the weight and sufficiency of the evidence.
So we've all seen the video, and when you look at this video and you see the bag flying around through the air, it's a little bit hard to think that there's a gun in that bag, isn't that so?
No, Your Honor, we would disagree with that. It requires a bit of an assumptive leap to conclude that just because a bag is swinging, it cannot contain a gun. There's no reason, based on the facts in the record, to believe that that's the case. But just to focus and narrow...
Consider the fact, can we consider the fact that he's seen patting his pocket?
Yes, Your Honor. We can consider the fact that the defendant was seen patting his pocket on appeal. I don't think, as my friend on the other side points out, that the teller did not specifically testify to that. However, it's certainly something that the jury themselves considered. They watched the video and they were able to see the defendant patting his pocket for approximately 10 seconds. And that went towards, presumably, their finding that the defendant had some intent to rob the bank through some display force.
The defendant testified in this case, and he said that his hand was in his pocket to turn off his cell phone because he had set an alarm to remind himself to commit the robbery.
Yes, Your Honor. That testimony is simply inherently incredible and non-credulous. Even if we were to consider
That
the
he
fact...
set the alarm so he knew how long the robbery should be or something like that.
Yes, Your Honor. Well, as a
Don't you
factual...
always set an alarm when you have to rob a bank? Oh, I have a doctor's appointment. Oh, I'm going to rob a bank? I'm not really. Why would that not be consistent?
Well, Your Honor, as a matter of factual record, the teller themselves did not testify towards hearing any such alarm. And so that's one thing that goes towards that point. But I'd like to just focus on two specific points. First, the proof at trial adequately demonstrated that the defendant displayed what could reasonably be conceived as a firearm. My friend on the other side mentions that words alone are not enough, and that is true, but we do not just have words alone here. We have words in conjunction with actions, in conjunction with surveillance video. In addition, the jury had every reason to credit the teller's straightforward testimony over that of the defendant. For example, the defendant during trial tried to explain away the patting motion by claiming that he was attempting to turn off an alarm. And the defendant also tried to sidestep the demand note itself by stating that although he handed the teller a demand note stating that he had a gun, he did not actually want her to believe he had a gun. Compared to that, the teller, on the other hand, had absolutely no reason to lie.
Well, he said at no time did he ever pretend to have a gun.
Sorry, Your Honor?
He stated that at no time did he actually pretend to have a gun.
Yes, Your Honor. That is what the defendant testified to. But the teller themselves had no reason to lie here and demonstrated extreme presence of mind by being able to remember bank protocol and activate the bank's silent alarm and hand the defendant debate money, even though this was apparently her first incident in which she received a demand note of that kind. The jury was therefore entirely warranted in crediting the teller's testimony.
I think she had only been a teller for like 2 weeks or something like that.
Sorry, Your Honor?
She had just been a teller for 2 weeks or something?
She had been a teller for a very brief amount of time, yes, Your Honor. But the jury...
Well, the defense also states that you really cannot credit her testimony as to the hand in the bag or the opening of the bag because she was obviously in shock and she was, what did they say? Frazzled, given the encounter.
Yes, Your Honor. Well, I would submit that any one of us would be frazzled if we were working at a bank and somebody came in to rob it and informed us that he had a gun.
Before your time is up, because I imagine the defense counsel is going to get to it.
Yes, Your Honor.
Supports affirming the 10-year sentence when you asked for 8 years.
Yes, Your Honor. The court should affirm the sentence of 10 years because it's only normal for the prosecution to offer a plea deal that's shorter than the ultimate sentence that the defendant did receive.
For 8 years at sentence.
Yes, Your Honor. But even still, the court was in the better position here, as sentencing courts are, to judge the conduct of the defendant and to determine what sentence is appropriate, having gone through the trial and listened to the defendant's testimony and seen his willingness to accept the responsibility and things of that sort.
What was the pretrial offer?
The pretrial offer, I believe, was 5 years, but I could be incorrect on that, Your Honor.
So pretrial is 5 years. At sentencing, you asked for 8, and then the court sentenced to 10.
Yes, Your Honor, but I would also note that that is only 3 years above the minimum, and the defendant here was a predicate with prior convictions for second-degree attempted burglary, third-degree robbery, and third-degree assault.
So, counsel, after the jury was polled, the defendant basically insulted and cursed out the jurors, right?
Yes, Your Honor. It's unclear from the record whether that comment was directed towards the prosecutor or the jurors, but yes.
So was that a factor in your view in determining the length of the sentence? And if it was, is that appropriate?
No, Your Honor, it doesn't appear that that was a factor. If you look in the testimony or the transcript itself, it appears that the sentencing judge explicitly states at some point that she can't take that into consideration, but she does mention it when she's talking to the defendant.
Which occurs, the judge has some, the defendant says some inappropriate things to the judge before sentence is imposed. What happened with the jury, you're asking for the 8 years after what happened with the jury, because he's not being sentenced as the jury comes back with its verdict. But then the judge gives the 10 years after the defendant goes off against the judge. Isn't that what happened?
Your Honor, the 10 years was a totally just punishment here, considering the extent of the defendant's crimes and his criminal history.
Yeah, but that wasn't the question that was just posed to you.
Yes, Your Honor. Well, even if I think this is a example of post hoc ergo propter hoc, if something, just because something happens afterwards, something, it doesn't mean that it's necessarily caused by that thing.
Thank you.
Thank you, Your Honor.
I would like to just focus on the excessive sentence point on rebuttal. The sentence of 1 decade of imprisonment was unnecessarily long and should be reduced in the interest of justice in light of the prosecution's own sentencing request of 8 years, defense counsel's request of 7 years, and the pretrial offer of 5 years. The prosecutor obviously took into account the nature of the incident, Mr. Flores' prior record, and the outburst after
So he
the
was
verdict.
a predicate. He was a predicate, is correct?
He was, and the
And it
prosecutor...
was a violent pred, right?
Yes, and to be clear...
And what was the prior felony conviction for?
Burglary, and Mr. Flores explained that that happened when he was 19, when he took an Xbox controller
So it was for
from his best
burglary?
friend's house. Yes. But again, the prosecutor took that into consideration and said that 8 years is sufficient under the circumstances of this case. The sentencing judge gave no adequate justification for going well beyond what both defense counsel and the prosecutor had recommended. I think the judge...
Would the sentencing judge be able to take into consideration the defendant's statements when he testified?
Yeah, she did, and I think she emphasized that when she imposed sentence, but
And
as...
perhaps may have been a little nonsensical or perjury there?
What do you mean by that?
That his statements may have been a little nonsensical, at least committed perjury?
No, I think he accepted responsibility at sentencing. Obviously, the displeasure at the verdict was...
He goes off against the judge before sentence is imposed. Isn't that the timeline of it?
I do not believe that that's what happened.
He went off after the sentence?
Correct, after a sentence was imposed. But again, summary contempt can be punished by 30
Why would he
days
go
in
off at the
jail.
jury when, at sentencing? I thought it was after the verdict.
So there was an initial outburst after the verdict was rendered, and both the prosecutor and the judge took that into account. The prosecutor said, in view of that, we believe that 1 year above the minimum is appropriate, so that's why they recommended 8. And again, summary contempt is appropriate. It can be punished by 30 days in jail. You do not need to go 3 years beyond that in order to impress upon a person the importance of respecting courtroom decorum. So on this record, the sentence of 10 years of prison is excessive, and it should be reduced in the interest of justice.
Thank you. Thank you both. Maldonado v. Hines.
May it please the court, Your Honor, my name is Scott Singer, and I represent the plaintiffs, appellants, respondents, Maldonado in this case. I've e-filed and handed up copies of 2 very recent decisions that I wanted to bring to the court's attention. One of them is Tompkins, a Second Department case that follows in a line of 4 or 5 recent Second Department cases that take a fairly narrow view of the integral part of the work defense.
Why would this not be an integral part of the work? We have electrical piping that's rising out of the ground, out of the floor, because they're installing turnstiles, right? Yeah.
That's correct.
So why would it not be an integral part of the work?
For one reason, because there was really undisputed testimony that these didn't have to project out of the floor. It should have been cut down immediately after the concrete was poured.
The job may not have been done the way it should have been done, doesn't mean it's not an integral part of the work.
Well, the protruding stub-up was not integral. It was not necessary. It was not going to be a permanent part of the structure. It was supposed to be cut down, and it should.
Put there for the turnstiles, so maybe the pipes could have been cut lower for the turnstiles. But those pipes were there in order to service the turnstiles, this ongoing construction project.
It was there, it had been there for a purpose, but it no longer was serving a purpose. It was just a hazard.
I thought the turnstiles were still being installed.
They were, but there was no indication. The proof was that these were supposed to be cut down to grade. That was in their safety plan.
That goes to a different argument, right? Maybe under 200, whether or not it should have been cut down, covered, marked off or something. That's not, that doesn't really affect whether it's integral to the work. They were installed in the turnstiles. They needed the electrical piping for that.
Well, I would submit that at one time it was integral, but it was no longer integral. It was just a hazard that was there that could have been eliminated. And as you know, the second department has taken a very strong position in these cases. They say if this is unnecessary.
Went by between the installation of those stub-ups and the occurrence of the accident?
It was at least weeks. I'm not sure the exact date, but it was a.
And how much before this had the floor been laid?
The floor was being laid 2 days earlier, but there was no floor being laid on the date of the accident or the date before. There was no proof that there was. The safety reports include that on the 16th, there was work on the floor, so it was presumably done before then. But there's no indication that the floor had to be laid before the stub-ups could be cut back. And I would just like to point out that in the Castaldo case, this was decided less than 2 weeks ago. This court said the defendants failed to show that the hose, which the plaintiff tripped on, was either in use when the incident occurred or was an integral part of the work being performed at the site. And we think that places a burden on the defendants to show that there was actually some purpose for the object that caused the tripping.
Why isn't that something that's maybe a little bit distinguishable? That's a hose as opposed to an electrical conduit that's going to be used to replace turnstiles.
That's correct. It's a somewhat different case, but they're both hazards that could have and should have been eliminated. And I think the court should understand the integral part of the work defense in that light. I just want to point out that the Bazdarek case, which was relied upon, Judge Shulman looks up, you were on that bench, it was decided by a 3-2.
No, I'm aware of that, but again, that issue, which is the very regulation that's implicated in the Turner case, not Turner, the Tompkin case you just provided us, in terms of a masonite board. And that's not debris and dirt, that's a masonite board. So then that will be something the Court of Appeals is going to have to consider, whether plastic covering of an escalator to paint, which is integral to the work, that's what you're referring to, right?
Yes, I just wanted to point out that it's going to be heard.
But that's markedly, right, but that's markedly different than a stub-up, which is necessary for the turnstile to function. We're not talking about coverings like masonite board. And by the way, our own precedents here are contrary to the Second Department with respect to masonite board.
Well,
as cited
there was
in the
a
Bazdarek
question of
decision.
fact in the case, as I recall. It was Krzyzewski, and anyway, they left a question of fact as to whether the only reason I'm mentioning Bazdarek is because it's going to be heard on Thursday, and the language and the way the court interprets, they haven't really. This is the first time I think they're revisiting this issue since O'Sullivan. The way they decide that would certainly presumably impact on the decision in this case. And I think that the defendant's reliance on the case may not be entirely warranted. As I said, thank you, Your Honor.
Good afternoon. If it please the court, Michael Shea for defendants, respondents, cross appellants.
So as to the Labor Law 200 cause of action, I mean, this would certainly seem to be because the stub-ups are an integral part of the job. a matter of means and methods, but yet it's your motion for summary judgment. Did you put in enough evidence to show that Turner and Hines are not responsible for what's going on the work floor?
I believe so, because the cases have held that the mere fact that the owner
Yes,
or really
O'Sullivan, this certainly
yes.
seems to be covered by O'Sullivan, but when you get down, it's your motion. How did you meet your burden here of showing that that Turner and Hines were not responsible for what's going on?
Because the mere fact that specifically really it's Turner, because Hines is the owner.
The owner.
Okay, so that the general supervision that they may have had doesn't impose liability upon them in this instance. And the fact was that there was works going on, as testified to by the 5-star. That was the electrical subcontractor who, as part of their scope of work, installed the conduits. His testimony was that it was his recollection that...
Because isn't there some suggestion in the record here, for instance, Chiarone's testimony that Turner was required to inform 5-star when a poured concrete was cured so that 5-star would spray paint or otherwise mark its conduit pipes. This doesn't suggest a detachment from what's going on.
But there was also testimony from the 5-star foreman, Chiarone, that he didn't have to be told because it was their custom practice and protocol upon installing the stub-ups or electrical conduits that their men knew to the deck crew, as he referred to them as, would spray paint them orange, usually orange, but it was clear that it was being spray painted.
So, but that doesn't establish that Turner didn't have the authority or the supervision over the electrical stub-ups, right?
Well, they had general supervision as a general contractor, but under the O'Sullivan case, the decision in that, the fact that they had this general supervision doesn't necessarily impose liability upon them under 200.
Certainly O'Sullivan is very strong authority on your support, but you still have the burden of showing that Turner and Hines are detached from the job, that they don't have this, that they have only general supervisory control, which under O'Sullivan wouldn't be enough, but you still, did you establish that here?
I believe we did.
Thank you.
I don't know, thank you.
Your Honor, let me just point out, O'Sullivan is a very different factual situation than here. In O'Sullivan, those stub-ups the conduits were 2 or 3 feet, rose 2 or 3 feet above the pavement level. They were obviously visible, and I think that led, in the way I understand the Court of Appeals decision, they said that was not an unreasonably dangerous work environment, and that's why they found Section 200 inapplicable to the case. This is a very different situation. We're talking about 4 inches. And even in their life plan and their safety
Doesn't it
plan.
hinge on the fact that general supervisory control is not enough to impose liability?
Well, there was very specific responsibility, as you pointed out, Judge Friedman, for the way this work was being conducted. It was not general supervisory control. So I think for those reasons that the 200s stand. I also think that I would just urge the court to consider whether the integral part of the work defense, as it's been interpreted, is really consistent with the language of the relevant regulation 23.1.7E2, because proper safety precautions could have been taken in a way that was consistent with the work being performed, and they weren't taken. There was no yellow paint, no orange paint visible. There was no, they weren't capped, and they weren't cut back. So for those reasons, I think that a violation of the regulation was established, and I would urge the court to reinstate the 241-6 case accordingly. If there's no further questions.
Thank you. You have 1 minute on rebuttal.
Unless the court has additional questions for me, I have Nothing further, and I'll rest on my brief.
No, thank you very much. Thank you
Thank you.
both.
Thank you, Your Honor.
245 East 19 Realty versus 245 East 19th Street. Justice Friedman is recused on this matter.
Good afternoon. May it please the court, James M. Catterson, with my associate Dante Apuzzo, from Pillsbury, Winthrop, Shaw, Pittman, on behalf of the appellants. This case is really nothing more than a garden variety breach of contract case based on a lease between plaintiff 245 Realty and defendant 245 Parking. There's no guarantee on this lease, and the lease was renewed several times during the term of the lease. Why are we here? Because the plaintiff having elected not to have a guarantee on this lease, and I would ask the court to ask itself the question of when the last time there was a lease dispute in this courthouse that didn't have a guarantee on it. I'll leave that issue aside for a moment. After the collapse of the economy in Manhattan due to COVID, the plaintiff concocted an on information and belief litigation narrative of a COVID-based scheme to defraud the plaintiff. The allegations on information and belief are made in this 319-page complaint. They're made 70 times. Fully a quarter of the complaint is pled on information and belief. Fraud is said 35 times. Scheme is said 26 times. The only evidence of this is the allegation of the following: that there was and this is from plaintiff's own complaint at 554, 556, 557, and 573 of the record, that there was a centralized cash management system with daily sweeps. That is the sum total of evidence of a COVID-based scheme. That is exactly the scenario that this court rejected multiple times. It is identical. It is factually identical to the 2022 case of Park Armory. In that case, this court said the allegations that those defendants, Icon, by the way, controlled and dominated defendant Park Armory management for the purpose of abusing the corporate form in order to divest assets from plaintiffs for their benefit are conclusory on information and belief.
Is there any, counsel, is there any, I guess, weight to the argument that maybe this goes one step beyond that, in that the company was rendered insolvent, unable to pay rent, and that was more so about the sweeping away of the money?
Several points to that, Justice Pittsburgh. First, this court has been absolutely unequivocal for the last 30 years that you cannot allege any form of fraudulent conveyance, whether actual or constructive, on information and belief. Indeed, Justice Gonzalez, you were just on a 2023 case, Barlow, that said exactly that. Remember, this case is entirely on information and belief. And I have to say that it is an unusual pleading because the complaint incorporates a series of civil cases, COVID-era cases, involving Icon that have nothing to do with this case. But more importantly, plaintiff relies on two affidavits by the CEO of Icon, John Smith. Those are at 547 and 572 of the record, and also in plaintiff's brief at paragraph 8, at page 18. And why do I say this? Because John Smith's affidavit directly refutes absolutely everything plaintiff pleads, and plaintiff incorporates it in their own complaint. Plaintiff says this is a COVID-era scheme to steal all of their money. Smith says, and this again is incorporated in their complaint, the cash management system, which has been in place since 2017, was set up to facilitate the efficient financial management of Icon's operations. And landlords have received payment of rent by check from Icon pursuant to this cash management system since 2017, that is years before COVID-19. That's in their own complaint.
Well, they're alleging that this practice started in April 2020.
That is absolutely, completely contradicted by their own complaint. If you look at page 72 of the record, that is an affidavit that CEO Smith submitted in a case before Justice Borick, where, by the way, ICON did have a guarantee in that case. Smith lays out at length that this started in 2017. He lays out that it's the industry standard for businesses that have multiple subsidiaries doing the same thing.
So you can have a cash management system that's fully operative and being properly used, and
Yes,
then
Judge.
deviate and decide to turn that money to your own coffers instead of paying the rent for the different garages that are turning over all of their revenue to you, right? So the fact that it used to be done the right way in the past doesn't necessarily mean that it's being done the right way now.
Well, that's true, Judge, but their own complaint pleads the opposite. They can't get past, and I said it's a curious pleading, they can't get past incorporating the Smith affidavit as part of their complaint and then denying its existence. It refutes absolutely everything they've said. And there are 5 cases from this court that support that a centralized cash management with daily sweeps, like this case, perfectly permissible. It's also perfectly legal to incorporate for the express purpose of avoiding liability. This court said exactly that in Skanska. Justice Weber, you were on that case. And it's insufficient to just plead that you don't have the assets to satisfy a judgment. That wouldn't allow you to pierce the corporate veil either. Let me end by saying this, and it's a case, Justice Shulman, you were on. The standard in Delaware law, now both sides said the case is governed by Delaware law, but New York law is the same, sort of. Delaware law says that the plaintiff would have to show that ICON, that the corporate setup here was a sham that exists for no other purpose than as a vehicle for fraud. There is no possible way. This would be the first complaint where this court, has invalidated a cash management system. Thank you very much.
Thank you.
May it please the court, Jake Beto for Plaintiff Appellate Respondent. The cash management system, and my adversary's emphasis upon it, is a red herring. Plaintiff does not deny that a cash management system, if used properly, can be a legitimate business practice. What is not a legitimate business practice is having all monies funneled up to your parent corporation, and the parent corporation utilizing its complete control over its tenant, over its subsidiary, in this case tenant, and directing tenant to cease paying rent.
So your adversary is correct that the affidavit from the CEO, John Smith, does state that the management system was in effect since 2017 and that it was never used to divert cash to HPS, and the HPS has not received any distributions, management fees, or compensation of any kind from ICON or its direct or indirect subsidiaries.
The Smith affidavit does not state that ICON did not receive funds. It cannot state that, and ICON doesn't claim that. ICON received all of the money. Every dollar that tenant received as part of their income went directly to ICON. And Justice Bluth found in RPH Hotels that ICON then utilized that money for its own purposes. It used it to pay off ICON's liabilities. It maintained all of the monies in a single operating account. ICON gestures to the idea that this was somehow an arm's length relationship, that there was a management agreement, and that this money that was received by tenant was somehow a payment, remittance for that management agreement. But that is not the case here. There is no evidence that there was a management agreement. There was no evidence that ICON managed tenants' funds in any way separate from its other entities. In fact, the Smith affidavit expressly states that all these entities were managed the same. And in RPH Hotels, Justice Bluth relied on the Smith affidavit and evidence adduced in that case to find that this entire structure was created in a way that ICON could funnel its tenants' monies up to ICON and use it as it pleased.
frankly, it's astonishing how much evidence we have to demonstrate that the veil should be pierced here. Not normally at the pleading stage, pre-discovery, do you have affidavits from principals at entities describing how they use the monies that they receive from their tenants to do what they please, describing their absolute control over these entities by directing them not to pay rent?
So, counsel, you're talking about all the affidavits. Your adversary is talking about all the sections of the pleadings that rely on, let's say, upon information and belief, and he says that's enough to discredit the complaint and basically toss it. What's the answer here? Is it that you don't have information? Is it you're speculating? Is it that you need discovery? Or is it that you have affidavits that are sufficient?
Pleadings, at the pleading stage, of course, the pleadings have to be construed liberally.
Well, this was a 3211 motion, correct? And we have two different parties. We have the HPS group and we have the ICON group, correct?
Correct.
One can view how these pleadings affect each one, particularly on this record where there may not have been a whole lot of information about the role HPS had here as limited investors, correct?
Yes.
Notwithstanding your position.
In terms of HPS, that's absolutely correct. But also that applies to ICON as well. We're at a stage, pre-discovery, where we have ample evidence that this fraud was taking place. We lay out in detail the exact schematics of the fraud, how it was that ICON took the money, used that money for its own purposes, left tenant judgment proof. And to have that type of evidence at the pleading stage, again, it's frankly astonishing. I would suspect that most cases in which you're pleading and seeking to pierce the corporate veil, or where you're seeking to show a fraudulent transfer, you don't have that vision into the internal workings of the corporation. We do here. And the fact that they continue to focus on this cash management system, again, as a red herring, to say, oh, well, cash management systems exist. Yes, they do exist. There are entities that can use them properly. But what they refuse to address is that they, not only do they have this cash management system, but they used complete control over the tenant in order to direct the tenant not to pay rent, continue to collect rent during the COVID period while they could not be evicted, and then kept the money for themselves. And to address, at the start of my adversary's argument, he spoke about that there was no guarantee and that somehow this should allow, I guess, tenant to act as it pleases with its funds. However, when you sign a contract with an entity, you assume that the money that goes to that entity can be used to pay rent. You do not know that the entity is going to take that money and funnel it to another entity, and then leaving the landlord with absolutely no ability to satisfy a subsequent judgment. And so the idea that somehow this is the victim's fault, I think, is incorrect.
Thank you.
Good afternoon, and may it please the court, Justin Ellis, Molo Lampkin for the HPS defendants. Today, I'll focus on the fraudulent transfer counts because that's where the landlord pins its hopes against HPS on appeal. I'll also talk briefly about the landlord's request for discovery. I've got 3 quick points. First, the fraudulent transfer claim has been waived. Second, it fails on the merits. And third, the landlord cannot get discovery against HPS under Rule 3211D. First, waiver. The landlord now alleges that the liens are fraudulent transfers, but it admits it never raised this claim below. Landlord says that's okay because under the Tolero case, this is a legal argument that could not have been addressed below. That's just not true. Had this theory been raised below, we could have responded below. For example, we could have countered their claim that the tenant didn't get value for the liens. We also could have clarified what the landlord is seeking. We don't actually know what relief the landlord wants or how that relief would make any sense. By, in essence, raising a new count in an appellate brief, the landlord has denied both us and the trial court an opportunity to respond. Tolero does not permit raising new claims by ambush in this way. As we noted on pages 17 to 18 of our brief, this court does not allow raising new theories of liability for the first time in an appeal from a motion to dismiss. Landlord does not and cannot distinguish those cases. Besides, this court only forgives waivers in its discretion if the interests of justice support it, and justice does not support that result here. That's because what you have before you is the third version of this claim. This has been a consistent pattern. The landlord keeps adding and dropping new theories just as soon as we refute them. Every time we knock one down, another pops up. This has got to stop. Litigation is not a game of whack-a-mole. Despite multiple attempts, landlord has never pleaded anything remotely nefarious about HPS's relationship with Icon. That leads to my second point. The landlord's new fraudulent transfer claims are just as meritless as the last two were, because the claim just doesn't make sense. It relies on the idea that these liens somehow prevented the landlord from collecting its rent. But that's not how liens work. The liens didn't stop the tenant from paying its rent any more than my mortgage stops me from paying my grocery bill. And as we explained, HPS never held a secured claim under the liens. Besides, unwinding the liens wouldn't help landlord get its rent. It's not as if the landlord is alleging the tenant's got some pot of money that could pay rent but for the liens. And in fact, just to be honest, the liens don't exist anymore. They were released in 2023. Besides, the landlord has zero allegations showing that the liens lack equivalent value. You can't just point to a transaction that you're a stranger to and say that it must lack value for that reason. But that's all the landlord has done here. That's just not enough to state a claim. And the landlord is also wrong on the facts. We've made clear that both Icon and the tenant got the value for the liens. What they got was access to letters of credit. Those letters of credit keep Icon and the garages afloat during the pandemic. And they gave up very little in exchange. Because a tenant got equivalent value, the fraudulent transfer claim fails. My third and final point, the Supreme Court was correct to deny the 3211D motion. That rule requires a sufficient start to show that the claims had merit and could prevail if only the plaintiff had more information. That's not the case here. The plaintiff had lots of information that it attached to his complaint from years of discovery. The problem is it just refutes the plaintiff's claims. It shows that Icon never transferred any money to HPS after the pandemic, and it shows that Icon is not controlled by HPS. The landlord's not entitled to keep digging in the hope that something turns up. This case needs to come to an end as to HPS. If there are no further questions, I'd ask that the order as to HPS be affirmed in full.
Thank you.
Thank you.
Identical allegations, absolutely, unequivocally identical allegations were made in Park Armory, Carlisle in front of this court in 2018. The claims were rejected because allegations made on information and belief are insufficient. That's what the court said in 2018. South College Street in 2021, this court again, sweeps of bank accounts on a daily basis. And by the way, the sweeps did not occur for the first time during COVID. They know it. Plaintiff absolutely knows it. The record is clear because that's what Smith wrote in both affidavits, that they began the cash management sweep system in 2017. What did Icon do with the money? Well, we all know the economy collapsed. From Smith's affidavit, page 81 of the record, Icon has used funds in the paymaster account in the ordinary course of business to pay direct operating expenses associated with the garages, including but not limited to employee salary and benefits, union dues, workers' comp insurance premiums, as well as general administrative overhead. What did Icon provide for that? Bookkeeping and administration, financial reporting, scheduling, supervision, repair and maintenance of garages, and it goes on and on and on and on and on.
So going back to your adversary's argument, it's a 3211, so should we not liberally construe the allegations?
You know, that's the most, Judge, I'm glad you asked me that question because I didn't get to it. That might be the most interesting part of this case. Normally, that's true in a 3211 motion. However, this court has said, it's in Biondi in 1999, and it's adhered to it ever since, that whereas here, Supreme Court has considered extrinsic evidence, and that's the extrinsic evidence that plaintiff attached to its own complaint. The standard of review under a 3211 motion is whether the proponent of the pleading has a cause of action, not whether he stated one. It's a tougher standard when you rely on extrinsic evidence. And I say to this court, beyond shadow of a doubt, from Record 72 on, the Smith affidavits, as well as their own brief incorporating those Smith affidavits, demonstrate that this was a legitimate business practice, that the only reason they stopped paying was because they had no revenue, and that they withheld money to pay all of the expenses. They didn't prioritize the landlord, all legitimate business practices that Smith identified at length across 36 paragraphs and 12 pages in an affidavit that they accept. This is not any different from Park Armory, from Carlisle, from South College Street, from Park Towers South.
So this is basically just a non-payment of rent and nothing more. That's your argument when it all boils down to it, right?
Yes, Judge. And I'll leave it with this. Park Towers South case, it's a New York County Supreme Court case. In that case, the plaintiff moved to implead Icon. And the judge said, no, this is a routine landlord-tenant dispute on which you have no guarantee. You can't plead your entire case on information and belief and expect that it gets past 5 decisions from this court. Fully 1/4 of their pleading, if you take out all the claims for relief and the charts, there's a lot of nice charts in there. If you take all that out, over half of their complaint is pled on information and belief, which this court has said repeatedly is insufficient to plead any claims.
Counsel, but if your basic argument is that Icon triaged revenue given the pandemic so that the people got paid even if the rents were not, what's the problem with going to discovery and showing all of that in black and white?
Because it's not sufficient to pierce the corporate veil vis-a-vis Icon. Because there's no question on their own complaint and the exhibits they adopted that Icon was no sham. And that's the heavy burden they have. Remember, veil piercing is an extremely narrow doctrine. Virtually all of you on this panel has said that at one time or another. It is an extremely narrow doctrine. You can't plead an entire claim on information and belief and then just say, well, I'm going to pierce the corporate veil. This court on motions to dismiss, every single one of those cases I listed, every single one, motion to dismiss. Thank you very much.
So counsel, working backwards, could you discuss the discovery under 3211D and also, excuse me, the fraudulent conveyance?
Yes, so in terms of the existence of the lien, we don't merely plead that the liens themselves are evidence of a fraudulent transfer, although they are. And Presley v. Penn-Medex, which we cite, is a case that indicates expressly that defendant was a transferee within the meaning of the DCL as it received a security interest in defendant's property. In other words, a lien on its own is a security interest. It is a transfer under the DCL. In terms of the Telluro rule, my adversary has indicated that he could have offered some kind of defense below. We've had this discussion numerous times already this afternoon. This was a motion to dismiss. It's based on the pleadings, so my adversary actually could not have submitted an affidavit indicating as to what exactly those liens were provided for and what sort of remuneration HPS received. On a motion to dismiss, the Telluro rule is particularly applicable because we're dealing with simply the pleadings and no evidence. And so, of course, on a de novo review above, the court can consider these arguments. Turning to Icon's arguments, the Smith affidavit was quoted indicating that monies were paid, to employees, et cetera. I don't doubt that they were. However, in RPH hotels, in which the court permitted discovery to proceed, the court found that the record shows that Icon dominated and controlled these entities, not just the entity in question, all entities. These entities by conducting daily sweeps of the garage bank accounts into the Icon account, thereby rendering each garage insolvent. There is no indication those monies were returned to the garage LLCs. It seems that Icon simply kept the money to pay off other bills, sometimes for other garages.
Counsel, if you would just stop right there 1 second. So when you say other bills, there is somehow an inference that bills inured to Icon and not to the garages. But just a few seconds ago, you said that there was no reason to doubt that monies were paid to cover salaries in the various garages. So under the circumstances of the pandemic, why would that not be acceptable? Or am I going off? Am I going to horse the record?
No, you actually are leading directly to the end of the sentence, which is, and sometimes for Icon's own expenses. In other words, they took these monies and they used it however they pleased.
But that was that was is that an allegation based upon information and belief, or that's because you know something?
Well,
And what struck me is what you just read, you stated, it seems like, that, did you not, when you just read that section, you also stated, it seems like, Icon was, the term it seems like was in there, right? Which would appear to be speculation and not based on any actual information.
that was Justice Bluth's decision granting summary judgment in favor of the
Yes.
landlord. And so Justice Bluth she found that this was a fact in order to grant summary judgment in favor of the landlord, allowing them to pierce the corporate veil and allowing the fraudulent, or granting summary judgment with respect to the fraudulent conveyance claims. This was not mere speculation. This was a
Well, it
finding.
seems like that term alone leads me to believe that there's no real basis for the ultimate determination. But I'm sorry, proceed.
Well, the court found that Icon was using these funds to, in any way that it pleased. It's clear throughout the decision, and that's why summary judgment was granted in favor of the landlord in that case. Judge Bluth, and by the way, this decision that I'm referring to right now, this is a granting of summary judgment that was not available at the time that the court below briefed the instant case. And so these are new facts that we learned subsequent to that, which are cited in our brief, but which make clear that Icon exercised complete control over tenant, that Icon used tenant's funds how it pleased, and Icon had absolute control over determining whether or not the tenant paid rent. They also make clear in that decision, by the way, to discuss various badges of fraud, makes clear that there were no corporate officers for these affiliate entities. Icon, again, because it had complete domination or control, did not bother to install any sort of leadership. There was nothing at all that the tenant had. The tenant had absolutely no discretion or ability to make any determinations. Icon made all the determinations on its behalf. So if there's no further questions, I'll yield the remainder of my time.
Thank you. Thank you all.
Thank you very much.
Last case for argument is Mercedes v. Cool Wind.
May it please the court, Cesar Pereira, Shepard Mullen for Sumner Manufacturing, defendant appellant. The issues before the court this afternoon raise a narrow procedural issue as to the scope of the remedies available under CPLR 3211D in the context of a motion to dismiss on the grounds that there is no personal jurisdiction over the movement. In this case, defendant appellant has no objection to the court's finding that the threshold showing that there are sufficient facts to establish the need for jurisdictional discovery. Where the court should be reversed is granting unlimited discovery of defendant appellant. What should have occurred in this case is the court should have either held the motion in abeyance or denied without prejudice to renew at the end of only limited jurisdictional discovery. This case arises out of a personal injury case involving the operation of a lift. The plaintiff commenced the action against defendant appellant Sumner, the manufacturer of the equipment.
So if in fact the discovery request is overbroad, can you then not move for a protective order?
So Your Honor, the issue here is that this motion was not made in the context of discovery. It was made in the context of a pre-answer motion to dismiss. And the grounds in which the motion was granted was simply the 3211D defense that additional information is required. And there's a balanced approach that the precedent in the state of New York that balances the movement's rights to not be fully pulled into.
So you would be precluded from moving for a motion for a protective order?
I would, not that we would be precluded, but that should not be necessary in the context of a pre-answer motion to dismiss. What should have occurred is jurisdictional discovery, and if there are sufficient grounds to oppose a motion to dismiss, then the motion is denied and the case proceeds.
First of all, 2 points. Didn't the court below deny your motion without prejudice?
It did, Your Honor.
That's an operative word, correct?
Correct, without
And
prejudice.
that means that you have the ability, even if you had complete discovery, or you were burdened with complete discovery, at the end of the day, you could make that motion, correct?
We could, Your Honor, but...
And this whole notion of compromise, wasn't that first raised in oral argument?
No, Your Honor, we, in reply to the opposition to our motion, when the only opposition we received was that there was additional information needed, we said that if additional information is needed, then the 3211D precedent allows for limited jurisdictional discovery to allow the non-movements to oppose the motion, and then the motion should be refiled. The concept here is that, in this case, the defendant should be not subject to the full jurisdiction of the court for discovery purposes. There should be a limitation in order to protect the appellant rights, both due process rights as well as statutory rights. And there's a limited procedure that's available in the context of a pre-answer motion to dismiss for lack of personal jurisdiction. That's actually all I have, Your Honor. Thank you.
Good afternoon. May it please the court. George Cornell on behalf of the defendant respondent Hellman Construction. So our opposition to this appeal is basically based in discretion. The lower court had discretion to determine not only to deny the lower motion to dismiss based on lack of jurisdiction, but then thereafter deny the alternative relief to limit jurisdiction discovery to jurisdictional issues. There is no precedence, and none was cited, that says the court had to limit discovery to jurisdictional issues. The court is provided discretion to do what it believes is just. In this case in particular, that discretion was appropriate because this case includes allegations of products liability, which of course are brought against the list manufacturer. So as was raised during the oral argument, the issue here is that how do you limit discovery to jurisdictional issues where we were told during oral argument that the manufacturer is not going to want to give over discovery about the lift and its manufacturer, and most importantly, about its distribution, how it got here to New York. Those are issues that are both important to the facts of the case, but also to the jurisdictional issues. If we're going to get the manufacturer in here on just one possible way would be through the long-arm statute that the lift was manufactured outside of New York and then injured the plaintiff in New York, we of course are going to need discovery and evidence about that. And if we are not going to be allowed to get evidence about the lift, then we can't determine those jurisdictional issues. So Judge Perry below heard all those arguments and believed, and as he was allowed to do in his discretion, that the more sensible and practical approach was to permit discovery to continue, and as Your Honor mentioned, absolutely to deny the motion without prejudice. Sumner can bring their motion again when they feel like they have more evidence that they believe would show they are not have jurisdiction in New York. But what Judge Perry did was absolutely permissible in his discretion, and we believe that Sumner here has not shown an abuse of that discretion. And
do I understand that you're arguing judicial economy? Because it's a twofer. The discovery is all-encompassing instead of being a two-part process?
Yes, I guess you could say judicial economy. But respectfully, Your Honor, what I'm really trying to say is, how can we determine if there's jurisdiction here if we're not going to get evidence about the lift? And that's really one argument. We don't really know what could come out in discovery. But if we're trying to say New York has jurisdiction over them, mainly because of this lift. How can we determine if that's the case if we're not going to get evidence about that lift? So it really becomes an argument practical. You know, how can we really limit this to jurisdictional issues where there's so much overlap between them? And that's really clear in the transcript and below. And that's an argument why the discretion here was not abused. Thank you.
Thank you.
May it please the court, William Goodbody for defendant respondent Cool and Ventilation. My response is very similar to that of Hellman, so I'll just supplement that somewhat. As it relates to the relief provided by 3211, counsel used the word allows. It does not mandate. And in fact, one of the options pursuant to CPLR 3211D is that facts essential to justify opposition may exist but cannot be stated. The court may deny the motion, allowing the moving party to assert the objection in his responsive pleading. By essentially denying the motion and without prejudice, he has done exactly this. So he is using the relief provided to him by 3211D, and there has been no abuse of discretion as stated by my counsel. And in support of that, the court weighed the fact that since 2016, there have been 805 lifts sold in New York. Since 2016, there's been $1.4 million worth of revenue by Sumner in New York. And this was information not provided by the defendant respondents, but in the appellant's own affidavit from his own client.
But your adversary argues that that amount is de minimis and doesn't really establish sufficient contact with New York.
I would tend to disagree that 805 lifts and $1.4 million in revenue is de minimis, especially when the standard is fortuitous. Sorry, I have it right here. It's more than a fortuitous circumstance that the lift appeared in New York, not to mention the fact that their parent company, which is Southwire, specifically on their website, markets and advertises these lifts and where you can buy them in New York.
Yeah, I think your adversary's argument, though, goes to the scope of the discovery. The fact that it is, wholesale, it's too broad.
Well, Your Honor, we haven't even gotten to the discovery aspect yet because we're simply trying to get an answer.
Right, so that it should be limited, that it should be limited at this point in time.
And then without rehashing everything that counsel just said, those would be my arguments to that. I don't want to waste the court's time and rehash what was just stated. And if there are no further questions, I'll rely on my brief at this point.
Thank you.
Thank you.
You do have time on rebuttal.
Yes, Your Honor. On rebuttal, I would make 2 points. First of all, there is no precedence in the record to say that this is an abuse of discretion standard. There's a clear established precedent in the state of New York in this context of a pre-answer motion to dismiss based on lack of personal jurisdiction. There is a balanced approach that the court has applied consistently to allow limited jurisdictional discovery. The opponents would be allowed any discovery required to establish jurisdiction. If they need to look at contracts, if they need to ask a deposition, relationships between the parties, between parent and subsidiary, how the material got into the state of New York, they'd be entitled to all that discovery, but only to the extent it's relevant to jurisdiction. The reason that for the balanced approach is there's this whole other set of protections that a foreign entity has from being pulled into the jurisdiction of the state. And that's the reason for this balanced approach in this context, is to protect both parties. On the one side, the non-movement's right to get enough information to oppose the motion, and on the other side, the foreign entity's right to not be pulled into a state that they shouldn't be pulled into. And this is a very balanced, reasonable, sensible approach. It's unlimited discovery of issues relevant to jurisdiction. And there's no case law that's been established here that says that this is some discretionary act. It exists because there was an important balancing approach that the Court of Appeals had to follow and has been consistently followed in the state. Thank you.
Thank you. Thank you all.
Oh, no, no, no.